Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friends Omar Serrato, the Tilted Lawyer, and Bruce from Oregon, who is about to be, I think, Bruce from Oregon, Wisconsin. Apparently that's a thing.
Oh boy. The house is coming apart, guys.
Yeah,
Ladies
right?
and gentlemen.
If you
things are
don't
happening.
recognize Bruce from my channel, you might recognize him from Dave's channel, or maybe you recognize him from Management Best Practices. If you want to get educated, go over there. We're waiting on Omar because he is finishing his setup over there. And Omar, we all know that I like to harp on Omar's silky smooth voice, which everybody loves. But his Rodecaster audio system is broken. And so he's going to sound like he's in the bathroom for this stream, but we will be able to understand him. So unfortunately, it won't be quite the radio voice you're used to, but it will be intelligible. Well, the sound, not the words, but you know. We're going to have a very casual stream here tonight, guys. Some updates in the Blake Lively, Ryan Reynolds, Justin Baldoni saga, but it's unscripted. We're just going to talk about some stuff that's come up recently. It's just going to be kind of fun hanging out for, 45 minutes, an hour or so. So if you're here for totally like on point, analysis, stuff like that, maybe this isn't the place for you, to be honest. So just know we're just here to have fun tonight. We're going to talk about some of the subpoena updates with Omar when he gets back from whatever the hell he's doing.
Yeah, pro tip, guys. Ladies don't like it if you take too long refilling the diffuser, if you know what I mean.
Oh, hey, I don't know anything about that. AKA the cat lady is here. She says, is Bruce the lawyer or the class clown tonight? I'm the class clown. Bruce is the special guest. Omar's the lawyer.
Boy. Well, cat lady, as your fake internet lawyer, my advice is to not commit crime.
Yo. I mean, that's good advice. That's good advice. Maybe you tell that to Blake's lawyers, because it seems like they have stretched the boundaries a little bit.
Pro tips, my friends. Don't commit crime.
The diffuser is back on. Hello.
We're ready. We're ready.
I was just we're live, dude.
Yes, ma'am.
Okay. Well,
I have knowledge.
I was just talking to everybody about how you're going to sound like you're in the bathroom tonight because your kids broke your Rodecaster. They spilled some juice on it or something.
Yeah, I used to have 2 Roadcasters, and I only have 1, and I transport them back and forth, and I just left at the office. Oh, well. What are you going to do? Yeah. It was a shitty day.
Just Mike.
Can you sing? It gives good reverb. Like I hear, Weird Al, when Weird Al was making his demo tapes with his accordion, he recorded them in the bathroom because the acoustics would give him some reverb.
You know a lot about that.
I think Weird Al has a record career. It really just speaks to the fact that you don't have to have any real talent. You just got to have pull yourself up by your bootstraps and put something on tape, and maybe it'll hit.
Oh, come on. That guy is a consummate performer. Come on.
Well, that's what it is. He's like the...
He has perfected his craft.
Oh, you know what's
funny? The Gangnam Style guy. That guy is a consummate performer. It's like Jesus with that guy.
Oh, boy.
Where did he come from?
You know what's funny is Justin Baldoni told this story about how he bought a printer. I think it was a printer from Weird Al, actually. And he went up to his house in like Beverly Hills and he hands him the printer and he was like, oh my God, this is Weird Al. And he gets back home and the printer didn't work.
Oh, bummer. Yeah, Weird Al made my airplane flight from Oregon to Wisconsin late because he had a connection.
Oh.
And he and his band got on the plane last. They held the plane for him. I sat next to one of the people in his band.
What would it be like to be that important?
What's up?
Also, I didn't realize you had all... What's up?
Oh, just shouting out Redondo Beach. She says you just need grit. She's going through a hard time. She's having she's going through some things. And I'm just good to see her in here as always.
We are here for you.
But she had reached out to me about our race, Omar, actually asking about that. Our race is going to happen in a little over a month at your mom's pool.
No, it's not going to be in my mom's pool. It's going to be in my...
We're not doing this? We're not doing it at your mom's pool?
No, man, it's too small. It's too small.
I thought that was going to be helpful for you, but I'll deal with the community.
You're not going to use it?
There was an Olympic-sized swimming pool in my community center. We're using that. And I've been training really hard. I don't know if I'm training the right way. I'm training the only way I know how. I'm prepping for a wrestling match.
I'm a little disappointed. I was working on a stand-up bit about how your mom's pool is so big that I'm not done with the punchline, but now I can.
I'm pretty sure. I'm laughing because I'm pretty sure that predated our arrangement. Oh my god! Somebody asked if that's going to be live streamed. Let's say we'll tape it and post it after the fact, so I can black box my ass just in case, you know.
I told Dominic that we're going to need him to film, so we might as well live stream it if Dominic's going to be there.
Like I said, I want to black box my ass.
No, don't do the black box. Do the red MS Paint like they did in The Bachelor because they had the Baywatch date, so they had red swimsuits.
Baywatch. Well, we'll have to do like a Baywatch run up to the pool.
And they use MS Paint to do the red on like Gabby's butt for her red swimsuit.
Oh my god.
Yeah. What are you talking about?
Oh, Schnitzel Ninja's here. She said, "Didn't you guys hear I'm filming?" I wish she would film. We're gonna open up. We'll open up the GoFundMe or something soon to get the donation links going. And then, guys, if you haven't heard this yet, whoever wins the race is getting 60% for their charity, and whoever loses gets 40% for their charity. So it's pretty much a win-win. The only lose here is that I'm not getting to swim in Omar's mom's pool. So.
You want to know a fun fact? So in the midst of my training, I've been weighing myself with this app, and my phone has alerted me to the fact that I'm obese.
Brother.
What, no. Your phone?
My phone has told me, my app has told me that my BMI index is like 30 or something, and that puts me in the obese category. I'm 5'11".
Don't they have some new test where they figure out how much muscle mass you have so they can correct for that?
Have you guys ever gone in the egg where you like get weighed and your body mass gets measured and stuff like that?
No, maybe I'll do something like that.
They call it the pod, the egg pod.
The egg pod? Is that like what the Wovloves spit out of their cloacas?
Pretty much, except you go inside of it. Yeah. So when I used to swim, huh?
People are so ready for you to win. I just want to point out I'm fully expecting to lose, but I also want to point out that if I somehow happen to pull this off and win, I will be the sorest loser. No, I will be the sorest winner there's ever been.
You dick. I will tell your mother.
There's not a day that goes by. It's like, hey, Dominic, so how's your death nut challenge feeling? You want to arm wrestle, bitch?
Oh my god. All right. Anyways, we're here to talk about the updates in the Justin Baldoni versus Blake Lively case. There's been some stuff going on. I know, Omar, you and I talked with Anita last week about that whole Vanzen case, but that was before they confirmed that was actually the case that was used to obtain the subpoena. Do you have any immediate thoughts on that? Like when I texted you the next day and it was like, hey, the lawyers just confirmed that shit was used to get the subpoena. What was your initial thoughts?
My initial thought was abusive process.
Mm-hmm.
My initial thought was 47.1 shouldn't be a thing anymore. And then just to tie into Anita's theory, if they knew about this stuff, they got information, they got evidence that formed the basis of this lawsuit back in October with this subpoena. Arguably, they might have got it in August, whatever. They got a sham lawsuit to get more evidence to build a case. And they're claiming that this happens all the time. I haven't seen any attorneys that's ever seen a lawsuit that didn't have a named defendants at the very least. Those 1 to 10, and then they get the evidence they're looking for, and it's immediately just voluntarily dismissed. They didn't have to notify anybody of the subpoena. Therefore, no attorneys were alerted to it and could possibly object to it because of the breadth of what they were asking for. Like, look, you got a cell phone. I don't know how much data it holds. I think my phone has like a terabyte worth of data or something. Of that might be relevant to a lawsuit, might be like 1 megabyte.
I'm suing.
But then it haphazardly get to have all the rest of it. That includes like pictures of my family, videos of my family, you know, whatever other stuff, other communications of my clients, all this other stuff would become
your BMI.
And if I don't object, my BMI, they'd learned that I was obese. And then if I don't object to it, I waive those objections and then it all becomes admissible. It's sort of what happened to Alex Jones. that happened to him in like spectacular fashion. And so they get wind. I think that Anita's right. I think they caught wind that they figured out that Friedman was getting involved and that they were building a case probably for defamation and breach of contract against them based on some of the stuff that Ryan Reynolds was doing and others.
Yeah.
And they filed a prophylactic sexual harassment lawsuit because specifically in California under 47.1, it punishes defamation claims with the fee shifting provisions, treble damages, punitive damages, and all of that. And it would be further incentive for Friedman and parties, the Wayfarer parties, to not proceed with the lawsuit on defamation. So an extra layer of protection. And the sexual harassment allegations are so far-fetched. They're so ridiculous as to be unreasonable that I think that it's not that hard to find a jury of 12 to connect those dots and find that this sexual harassment lawsuit was not brought in good faith and therefore maliciously conspired to be a thing to defend against a lawsuit that they knew was coming. Now, they're going to have to prove a lot of things in between that, but I think that's the working theory. And so long as they could connect the dots enough, I think that 47.1 is not going to be a thing. What's up, Stephanie B? I ain't seen her in the longest. I don't know where Stephanie B's been.
Yeah, it's been a minute, eh? Okay, so by the way, I just posted a link to Anita's theory because people were asking where can I see Anita's stuff. She made a website. Yeah, she got a website today, and so I posted the link to it in the chat there. So if you want to visit Anita's website, you should. It's very thorough. She spent a lot of time on it, a lot of hard work, and she's like very well informed. Like she had to remind me and Omar of a lot of shit. So
no, she knows this shit way better than you and I. She just
like pretty much better than anybody as far as I'm concerned. I don't know anybody who can just, take that shit off the top of her head like that. Like it's crazy. Crazy in a good way.
I'm going to be going live with her tomorrow to promote her website.
Oh yeah, good. Okay.
And she said, there's like a major time difference, so we got to coordinate that. I'll work out the details with her. But people love Anita. And when you listen to her speak, she's got a bitchin' accent for one, and for two, she knows her shit, man. She's really bright.
Yeah, for sure.
So, and she has a theory that I've starting to notice other lawyers are picking up on. When she sprung it on me, it was like so much at one time.
Yeah,
it was not enough to like talk to her once and get the gist of it. But as this has progressed, the things that she has noted have all started coming to fruition. And so give her a visit on her website. People have been asking for her PDF. Well, the hell with the PDF. She's created a whole website.
Yeah, let me just pop in there right now. Hang on. Anita's theory.
Yeah. It can be very useful to review things that happened in the past that you may vaguely remember, but don't remember completely, just to refresh your memory. And because of the things that have happened since then, it can spark new links in your mind or creativity about what's going on. I've noticed this when I've, been doing some yard work or whatever, and I listen to some old videos about the Owens v. Eckerd case, and it's like, oh, this happened in February 2024. I never noticed this detail.
Speaking of,
it can be good to go back and look at the old stuff.
Speaking of Owens v. Eckerd, Justice for Clayton is in the chat. Thank you, Justice for Clayton, for joining us tonight.
Well, Justice for Clayton.
Yeah. We'll have to. Has Steve put out that latest interview with Rachel Juarez yet about the?
I heard it might drop Thursday. Whenever
that's tomorrow,
drops
right?
His Thursday podcast.
Okay, gotcha. Because I know he talked to Dave today, right?
Yeah, I don't know. Yeah, he was doing a spot on Dave's show, but I think he was going to put out his own thing with Rachel about the motion for reconsideration.
Yeah. I was like, what was that shit called?
I'm not covering that. Gingerbread. It's such a waste of time. I just, when it gets to whatever the thing is going to be, I'll cover that.
Omar, hang on. I'm going to post this link in Omar's chat too, because people are asking on your chat. I don't think it posted there. Hang on. Give me 1 second. To Anita's website here. If you're in Omar's chat right now, because we're multicasting.
I didn't see it in these.
www.Anita's.
There it is.
anitas-theory.com, and I posted that right there. So there you go. Lauren, did you have a gummy today? I did not. I'm waking up early tomorrow morning to swim with my sister because I have to get ready to race Omar. So,
To race
Omar? To race you.
Oh, to race. Not
Yeah, race. I couldn't raise you, dude. I'm not that strong.
No, the perils of being 34.
Yeah, right.
I know how old you are, Lauren.
I'll be your mom.
Omar,
You're always going to be your age +2 to me.
Omar has a super chat to read right here.
Justin Ricardo says, "Hit my bong and drinking for this. Let's go." Hell yeah. I'm drinking some Woodford Reserve, by the way.
So you guys have that in common?
Yeah. Is that what you got, Bruce? Nice. How come
this is lap 10, Lafrogue 10. Scotch.
Oh, that's why. It's not the.
I have a big jug of water. So same.
That stuff looks real dark. They finished that in sherry casks, or what are they doing?
Oh, mine? No, I don't think they finished it.
It's not talking about my water.
I can't tell what color it is because your whole you were purple.
I could tell you that on camera it looks darker than in my hand.
Yeah.
So there's that.
Very good.
Also, I don't think that the race is going to be live, Stephanie, because what if somebody's shorts fall off on accident and then
Yeah.
Oh, I'm down with that. I won't be wearing shorts. So that would be you, and that's fine with me.
We got to edit out all the wardrobe malfunctions, or we got to make a super cut of all the wardrobe malfunctions.
We could also just swim in extra layers of protection, but that would be way harder. So, we'll see.
Some prophylactic measures.
We'll discuss it.
Well, I'm just talking shit about my whiskey glass. This is a proper whiskey glass, sir. This is a Capita nosing glass. This is how you properly drink good whiskey.
Properly drink out of a red cup, you
It's a Glencairn, is what they call it.
Christina says it right. She says it's a sniffer.
All right. So we got one more question before we move on to the subpoena update some more. R. Higgins says, "Hi, everyone. So could any of these people be criminally charged? If so, who?" And I guess it's a question for Omar. Is it possible that any of these people would be criminally charged, and what circumstances would that require?
I haven't seen enough yet to bring up criminal charges. I don't know yet. I don't know. Potentially, but I don't want to put that out there just because I haven't seen enough facts about that. I've heard that theory floating around. I haven't seen anything that definitively points to criminal charges. I know people are anxious and want that to happen, but I'm just not going to analyze it until I see all of those angles. I don't know. Not yet. Maybe.
I say yes, but my handcuffs are plastic. So.
Well, what are you thinking though? In terms of criminal charges, if they were going to be a thing, what are they going to be about?
I have no idea. I was just being a clown.
Oh, well, right.
God. What are you talking about? Okay, hang on. Let's see. So I'm going to share this thing on my screen that has some updates about what was on the subpoena. So we can talk about that. And this is from Leanne Newton's Twitter account. Leanne is like the encyclopedia for this shit on Twitter. Because I was trying to find the article with it, and I was like, no, I'll just go to Leanne's Twitter. And you guys probably know who Leanne is, right? I mean, Omar probably does, right? If not, you're missing out. But you guys are not. Well, Bruce is on Twitter. I don't know if Omar's really on Twitter.
I've not been. The only time I've ever been directed to Twitter is when Gingerbread love tweets me.
I remember because I was so excited. I was like, Omar's on Twitter now.
I know I made it Twitter. I just don't ever use it,
Yeah.
I probably should.
His username is Omar69420.
I go there when I get notifications.
Bruce, I'm going to send you some notifications. Anyways, so here was the update on the Sham subpoena from a little bit more detail from Deadline. I think it was, she says right here, Deadline. Naming Lively, Reynolds, and the couple's various companies and entities, the subpoena concerns, refers, relates, and applies to any and all electronic records, data, documents, and communications in your possession, custody, or control collected from a cellular telephone containing the requested information from December 1st, 2022 onward. The thing about that is they had requested, in this case, to the judge, they tried to subpoena phone records back to December 1st, 2022, or sometime in 2022. The judge says, no, that was overly broad. But apparently they've already done it. So, a little weird, too.
Dun, dun, dun.
But also, like, they're asking for this specific information from this cell phone, from a cellular telephone containing the requested information. It's Jen Abel's cell phone. They already know what they're looking for.
Well, look, man, if there's going to be criminal charges, it's going to be because somebody made a false statement or suborn perjury on one of these subpoenas or these sham lawsuits.
Sure.
From what I've seen, I haven't seen anything that's been knowingly false. It's just an abusive process. That's not really criminal charges. That's civil contempt, maybe. That's at worst civil contempt. Sanctions, probably, or maybe just nothing.
Sanctions for
maybe
lawyers are easy to do, right? Because that's just
but sanctions, like, who gives a shit? Like, you're gonna get what, a couple $100 fine or whatever. What really would harm them is if, because it was found to be an abusive process, that whatever evidence came from that subpoena directly, whether it was Jen Abel's phone, all of the phones, all of the stuff, whatever it was. By the way, I think didn't you say that we know the contents of the subpoena now? Have you seen it yet?
This is like information about what was on the subpoena. We only knew that the subpoena came from that John Doe case. So now this is what was on it, I guess, is the subpoena concerns this cell phone, basically, and they want that information. Okay.
Well, I mean, if they can prove that there were knowingly false statements, then sure, criminal charges. Is it likely? No, it's just not. The real penalty is going to be that the evidence obtained from the subpoena and everything that it led to, which just might be everything, would be inadmissible in court. And if you gut their entire side and they have no admissible evidence, the only way they could ever even comment on evidence is if Friedman brings it up at trial, which puts them at a severe disadvantage. So that's the way, to me, that they're going to be punished. It's not going to be criminal charges. That's why I don't have much to say about criminal charges just yet.
Right. So with the just as far as the civil case goes, in regards to this, like, John Doe lawsuit for Van Zandt, who had nothing to do with Justin Baldoni, It Ends With Us, Wayfair, or anyone involved, for Van Zandt, who is submitting the subpoena asking for records from this specific cell phone. That seems a little off to me. Like, is that something that you think we'll see an actual, like, what are the odds that we see actual, like, sanctions or something for that? Like,
so concerns, referrals, relates, and applies to any and all electronic records, data. Well, here's the problem. Look at the breadth of what they're asking for. If this is really what's on the subpoena, all electronic records, that includes all cell phones, all PCs,
any and all
laptops.
It's very broad.
It's asking just from that cell phone, though. It says collected from a cellular telephone.
A cellular telephone.
That Jennifer Abel's cellular telephone that was taken by Stephanie Jones. Right there in the blue highlights.
Cellular telephone makes me feel old. Like, I called Mary Lincoln's on my cellular telephone the other day.
Go ahead, Omar.
Containing the requested information. What was the requested information, though?
All that stuff above.
From December 1, 2022 onward, that would be, by my math, that would be 2 years, almost 2 years.
Yeah, it would be over 2 years, wouldn't it? Yeah, it'd be almost 3 years, almost 3.
Arguably, yeah. The point is that this could have been objected to. It's not so much that this is criminal. It's just that this is such an overbroad request, and nobody was given notice of it. And they didn't have to give anybody notice of it because of the way that they did it, by not naming any defendants. And then they did get it. Stephanie Jones doesn't send this to her attorney because her attorney would have immediately objected.
Right.
And so then she just complies. Yeah. That is what we call, in criminal law, that's fruit of the poisonous tree. In civil law, the application would be similar. The tree becomes any information collected from the subpoena, and any fruits born off of that tree, meaning it led to this other evidence, all that shit, inadmissible.
And that applies to civil cases as well, or?
It does, but like in a different way. Like in criminal court, it's automatic.
Mm-hmm. Okay.
In civil court, it's within the discretion of the judge. But historically, they followed that pattern.
That's kind of along the lines of what Cassidy said. Cassidy O'Connell is another person I like to listen to a lot for legal analysis, and she said kind of a similar thing. Because I remembered that you had said something about the fruit of the poisonous tree, and she also mentioned that, but then she was like, it's a civil case, so it might not be, the same. It's going to be, maybe different based on...
They're going to argue for the point. Look, I mean, they're on firm... There's a firm policy argument that it should apply just the same in civil court.
Mm-hmm.
And the judge is going to be able to use discretion, where in criminal court, it's an automatic constitutional violation, but it's related to criminal cases, and therefore it's a little different.
Mm-hmm.
Civil cases, it's not technically a constitutional violation, but it's a shitty thing to do. So they're going to argue that all of this evidence should be admissible. Then we're going to have to get into the arguments about whether or not it's going to prejudice either party, and of course it is. There's going to be all kinds of prejudice to lively side and other considerations. So I think that it should work the same. It's just not automatic. They're going to be arguing that it should operate the same. Mm-hmm. Just not a slam dunk is all.
I need to get you and Cassidy together on a stream one time to talk this stuff out. That'd be great. That'd be so good. Oh, she's cool, man. She does videos, but she's got so many obligations. She can't be doing YouTube all the time, so she does videos every. It's like I want to say at least a couple times a week, but she's got a lot of great insight and stuff, and she was mostly talking recently about well, not mostly, but most recently, what stuck out to me the most was her talking about the New York Times and how this stuff kind of applies to them. So I'll show you guys her channel in just a second here.
Is she Cassidy O'Connell?
Yeah, that's Cassidy. Mm-hmm. Let me share that tab instead. There she is. Yeah, so you guys should sub to her if you haven't yet. But she's great. She's great. She has a lot of she does some stuff she's very succinct, in this 6-minute video here about the New York Times and the subpoena, but she has a lot of information and she explains it in a way that's very easy to understand as a layperson, which is what I really love. And also, I think I told you this the other night, Omar, it's whenever she's doing a video, I just want to curl up under a blanket and listen. I'm just oh, this is so nice. I don't know why. I can't explain it. She's a great narrator. So yeah.
Well, somebody just asked, is this case going to settle? No, man. I have no evidence to suggest that Friedman is interested in a settlement at this point. Why would he settle now? He's got the upper hand.
Mm-hmm.
They should be coming begging him for the settlement at this point. Let's rock and roll. If I'm Friedman, let's rock and roll.
Yeah.
Settle for what? Show me any evidence that you got a strong case that we're not going to prevail, because it looks to me like you just screwed yourself. I hope you enjoyed it, because you were royally screwed by that, and we're going to take advantage in every way possible. That's a line in the movie. Where was it from? It's Jennifer Lopez. It was a DV movie.
Shit, I don't remember. I think I know what you're talking about, though.
It was the most unrealistic, irresponsible movie about domestic violence I've ever seen, but it was entertaining,
I'm trying. I feel like I know what you're talking about. I just can't remember.
Oh, somebody knows. It was Jennifer Lopez and that other lady.
They're saying enough.
Enough?
Made in Manhattan? Wedding Planner?
No, definitely not Made in Manhattan. Where she beats the shit out of her that was abusing her. At the end. Enough. That's what it's called. Enough. That's what it's called.
Okay. Yeah, I just looked it up here.
That's what they're all saying.
See, the problem with that movie is women are going to think that, I just got to train for a couple of months and they'll be able to beat the shit out of a guy.
Oh, God. I mean, I feel like that's how I feel about our race coming up, Omar. I don't know. But as far as domestic violence, no, don't say that.
I'm literally training for 2 months. I have no illusions that I'm going to win this race against Lauren, but I'm going to try.
Well, I'm doing my best to make it easy for you. I've been a freaking lard for the last couple of weeks. Oh my God.
For months. Just go for the nuts. That's the trick.
Well,
I'm not going anywhere near his nuts. We're friends.
Oh, well, I mean, well, he's not attacking you.
Well, not yet.
No settlement.
Oh,
it's interesting. So, Omar, what you're saying is it's ill-advised to file a court action and not bring sufficient evidence during the court action.
No, you could bring a lawsuit without evidence. You could do that. Because you're pleading on information and belief, and then rely upon discovery to fill in the gaps. But usually you'll have evidence supporting your case before you bring,
To fill in the gaps.
Yeah, there's going to be gaps. You're not going to have proof. If you're trying to prove conspiracy, there are secret communications that you're not going to have a hold of, and you're going to have to plead very specifically what you think happened. And in the course of discovery, you're going to uncover what actually happened. You may have to amend your complaint after that, but it's allowed. It's allowed.
I was thinking more of like SH complaints or paternity actions.
SH is a little different because you should have been a precipient witness to everything that happened, right?
Exactly.
Oh, you were being facetious, and so I was
a little bit. The conspiracy thing is interesting given the recent Lori Daybell trial, but yeah.
Did you watch that?
Oh, that's another one I need
because
to catch
that
up.
was a conspiracy case.
Mm-hmm. Yeah, conspiracy by nature, you're not going to have all the evidence. It stands to reason that you could plead it on information and belief and plead with enough specificity so as to say what you think happened. And then you're going to have discovery either confirm or deny, or confirm conspiracy, just not in the way that you thought. Which is kind of, I feel like, the boat that Baldoni and the Wayfarer parties are in right now. They might not know all the moving parts. Like, for example, I'm to believe that they had no idea about this sham lawsuit that led to this weird subpoena that became the foundational piece that led them to this lawsuit to begin with, the CRD complaint and all of that. But it's a thing. So piece by piece, it's all coming to light.
Someone in chat mentioned the Neidigh case. I think in the Neidigh case, they probably had enough to bring a case, and then discovery is just going to aggravate, right? It's just going to multiply everything, right? It's not going to make the case.
Yeah, the problem with Neidhigh's case is that there's all these people coming out the woodworks with stories about how they were victims of Neidigh. And it turns out like more than half of them have been bullshit so far.
Mm-hmm.
Because, why not? I'll take my shot at a payday. Mm-hmm. That's literally what's happening with the Neidigh case. Like, there's some legitimate complaints, and there's others that have been dropped because it was confirmed to be lies because of evidence that they have. And so they're swatting away all these rogue cases. And people are thinking, Neidhigh's winning. He ain't winning shit. It's just they're getting rid of
the problem with that kit. They have a low signal to noise ratio then. Okay.
Yes. Yeah.
So, I have not been following that very closely. Some people sent me some links and stuff about it, and I was like, listen, if I haven't followed it from the beginning, it's going to take me time to catch up. That's going to happen on a weekend. I'm not doing it right now, so I actually don't know.
I just think sometimes it's interesting to see some of the parallels or, to compare and contrast some of these cases.
Yeah. Somebody says, Weinstein case is so important to Neidigh case too. What do you think about that, Bruce?
The what?
She says Weinstein case is so important to Neidigh case too.
Yeah, I mean, who knows if these things are related? They might be, right? Like, and the guy with his island.
Yeah.
Well, the issue with the Weinstein case, it's not really the same thing. I think that what happened in the Weinstein case is it created a strategy for defense attorneys that are defending against these SA and SH claims. Like in the case of Weinstein, it turns out that a lot of the purported victims had consensual relationships with Mr. Weinstein for years, and then all of a sudden it's a grape and SA and SH and all of these things, and they buried his ass in court. And not to say that he didn't do what he did, but there were a lot of victims that legitimately were consenting to what was going on because they were benefiting from it. Mm-hmm. But it didn't really play out that way in the Weinstein case. In the Neidigh case, we're wise to that now. We know that there's going to be victims that are going to come out of the woodworks and try to take their cut. And so they're having to play whack-a-mole with all of these bullshit cases. So that they do legitimately have cases that they have to defend. There's just a lot of bullshit out there as well.
Okay. I have a question for you, Omar, that I'm going to put up on the screen. I'm going to run to the bathroom real quick. I'll be right back. Here it is. Jackie Graham. Can Friedman actually sue Van Zandt for bringing a sham lawsuit as separate from current lawsuits? I'll be right back.
Why would he sue Van Zandt when he could go for those damages right now in the instant case? It would be, I think that the Van Zandt lawsuit becomes a piece of the conspiracy theory for the instant case. And Van Zandt is owned by the same parties that are in the instant case, so it'd be a waste of time to do that. I think more realistically, they amend their complaints to include the fact that this Van Zandt sham lawsuit was part and parcel of the conspiracy. And this sham lawsuit gave rise to information they wouldn't have otherwise had that tipped them off to the fact that there was going to be a lawsuit filed against them because Friedman had been lurking around since August. And so they think, hey, if they're clever enough to file these sham lawsuits, they're clever enough to understand that 47.1 just became a thing in 2023, and it has special protections against defamation lawsuits, where there's this fee shifting aspect that might frighten Baldoni into going forward with his case. And they sue in California, the CRD, while still trying to take advantage of law in New York. And at the heart of it is really a federal lawsuit, and put that and make it part of the conspiracy and just add to the damages in this case. What would be the point of bringing a separate lawsuit?
Is that the common recommendation or the common strategy in these cases? If you already have an existing action, oh no, where did he go? Guys, am I alone? I was going to ask, now I'm going to forget my question. Guys, what is happening? I was going to ask if it's common to just keep adding things to the existing case if it's within the scope of fees and sanctions or rulings that you can get, as opposed to bringing an entirely new action, which could be more complicated. Because this was an argument in the Owens v. Eckerd case as well. It's like, okay, well, we have a paternity case. Are we discussing fees and sanctions relative to the things going on in it, or should there be a whole other defamation case? So Omar, like, I don't know, are you back?
No, I'm back. I heard your question.
Did you hear my question? Okay.
Yeah. And so, no, I don't think that they would. It makes no sense to bring two separate lawsuits when all of the parties to that new lawsuit are here in the instant one. It would just make no sense. I think, if anything, it's a gift for the current lawsuit. It fleshes out a little bit of the conspiracy, and it allows a jury to understand that these people on the Lively side are bad faith minded. The kinds of people that would conjure up a malicious plan to conspire to remove Justin Baldoni for financial gain. And just sleazy enough to accuse him of SH, even though the basis of those complaints are bullshit.
Yeah, I noticed there was nothing about that in the Van Zandt lawsuit, nothing about sexual harassment at all. So, but like, they were just like, this will give us a boost. And then they decided to sell that to the New York Times. Of course, the New York Times knew about it shortly after the Van Zandt lawsuit because of the metadata that Leanne Newton, I believe, like we were just looking at her Twitter, the same user. And she was also on my stream last week when all this came out. Leanne uncovered the metadata that showed that the New York Times had been working on this since October. October 1st was when the subpoena by Van Zandt was issued. So way before the CRD complaint was filed or in motion, the New York Times apparently had the information from the Van Zandt subpoena. So curious as to any thoughts on that, on how that may be kind of questionable. Omar?
I missed what your question was because I was reading this other question and I was going to ask you a question.
Okay, let's start with your question and then we'll get back to mine. How about that? So
Granny Weatherwax says, so Omar, what do you think of Ask Two Lawyers saying that this is a great chess move? What do they say about that?
So I watched some of their stream yesterday. I think it was yesterday with the Josh, the reporter from Daily Mail, who uncovered this story alongside Without a Crystal Ball, who broke it the night before. But he, I guess, was talking about this with the two lawyers, and I think Stewart was the one who said it was like something. He said it was like a good chess move. That's not the word. Someone in the comments can probably tell us. I think people read into that like super hard and feel like Stewart is like pro-lively, unethical tactics or something. I don't think that's what he meant necessarily, but that is what a lot of people have interpreted as. But since you haven't seen it either, I don't know how much you can comment on that. But from where I stand, it's like
I heard him say something similar.
Yeah.
Is it with respect to the sham subpoena?
Yeah.
Is that what he's okay? So I would liken that to when somebody sacks the bishop on H2, king takes, knight moves to G5, check. King has to go back. Queen goes to H4.
Mister, what the fuck are you talking about? What?
That's a move, and you think you're being really clever. Like you'll be able to get people like rated 1200 and below on that stack. Yeah. But for people that see it coming and where it could be punished, if you go for that and it doesn't work, then you're fucked. Mm-hmm. And I feel like they went for a sack. They went for it was a chess move. It was a move. They thought they were being really clever, but they got caught. And now they have opened up arguments to them operating in bad faith, to them operating maliciously.
Right.
They opened up this theory that supports that they were conspiring all along to take this movie. They were aware that this defamation case was coming, and they were also aware that it had teeth. And to protect themselves, they sacked their bishop on H2. Well, H7, I guess, would be if you're playing the white pieces. And, well, God damn it, it didn't work out because the king had a square. If I had a chessboard, it would make more sense.
I think we need a better analogy.
Listen, bro.
I'm just going to say this.
What are you talking about?
Understanding, like, look, I can say, like, if you go back to the OJ case or something, I can say, look, Barry Scheck did a lot of clever things. I may not agree with everything he did or think he's a good guy, but I can at least agree he played a good game.
Oh, Stuart's here. What's up, Stuart?
You know what I mean?
How's it going? Stuart from the Two Lawyers is here. Hey, Stuart.
Oh, is Stuart the one with glasses?
Yeah, did you know Stuart ran for Senate?
He's right in the
I didn't know that.
Yeah, man. I was like, I'd totally vote for you, and then I realized I live in Florida. So...
Yeah, the thing I was going with my analogy, Bruce, it's just like if you play a sacrifice like that, it's a chess move, and it's going to work a lot of the times.
Glasses and all.
But Brian Friedman is a chess master, and he knows how to deal with that, and now he's got hold of it.
I mean, either side can, win a battle, but who's going to win the war? That's the question, right?
I don't know. In my opinion, I think that Friedman has, because of the sham subpoena, ample ammunition to attack. I think best case scenario, it ends up gutting their lawsuit because of all this, the fruit of the poisonous tree theory. I think at worst, it's going to be, some kind of admonishment from the judge and nothing really happens. But I think that it's something that you can argue to a jury where you have to prove malice and where it might tie into 47.1 and it may be a defense for Baldoni in stating that the SH claims were never serious. It was a prophylactic move on their part to guard against what they knew was going to be a coming defamation claim. And if they were clever enough to come up with the sham subpoena idea, they were clever enough to understand that 47.1 was a thing in California. And therefore, because these were what essentially amounts to frivolous sexual harassment complaints, they should not have the protections under 47.1 because that's not what it was intended for.
Where was the original defamation claim or threat coming from?
From, what do you mean?
You said it was a prophylactic move to
because her CRD complaint,
pending defamation, but where was that original threat originally?
In the California CRD complaint filed on December 1, followed by this.
But that's their own action. That's not a defensive move. That's two offensive moves.
So what I mean by prophylactic is they went on offense to play defense. See what I'm saying?
They went on offense twice.
Yeah, so they went on offense.
Play defense against something they didn't even know was coming?
No, that's my argument. They knew that it was coming because they saw the text messages.
From who?
The sham subpoena. Because they got text messages. They knew Friedman was involved. They knew that there was communications about a lawsuit that was pending and what else is it going to be. They're worried about a defamation case coming. Let's just file an SH claim, go to California, file the CRD,
Yeah, this is interesting.
7.1, that's a defense against defamation that's going to make them think twice and proceed that way. Not understanding how much this was going to blow up.
This is why the timeline is so critical here. Yeah.
Anita's got the timeline down to a T.
Yeah, exactly. That's
need
why
that. Yeah.
she
Well,
can answer all my
guys, somebody
questions.
says put Stuart on. Stuart, if you're still here with us, if you want to join us, please
Yeah.
let me know. I don't know how to send you the link though, so I could send it
I
to
would
you
be
guys on Twitter.
fascinated to hear him talk
know.
about the chess move thing.
Yeah, same. I would
If you
love
have
to
a
have Stuart on.
Twitter account, send Lauren a DM.
Yeah, I'll even endorse you for Senate.
In Florida?
In any state, I don't care.
Stuart's Law office is like 15 minutes from mine. He's in
Oh,
I think
dude.
he's in
No, you know what? Because I'm going to be out there to raise you, obviously. I'll be there on my way to Australia, so maybe I could meet up with them too. That'd be cool to meet them.
Maybe he could be the
We'll
judge
see.
for your swim meet.
Yeah, dude.
Yeah.
He
Motion
can
to
hold the
compel lunch.
camera.
Motion to compel lunch impending.
I'd love to, but I'm in bed. You young people are up too late. Oh, that's okay, Stuart. Thank you for joining us in the chat, though.
Well,
You can still hold the camera for a race if you want. Oh man. Oh. You had another super chat here, Omar, if you want to read it. I think it was a little bit ago. Sorry, I didn't get to it before. It was 20 minutes ago.
Sure. It says, doesn't that breach the other client's info? In healthcare, we'd be fined for each person by handing over a phone, PC. Maybe, but who are you penalizing? Because nobody objected. I mean, I don't know. Yeah, because they certainly got into other clients' info. They had everything. I mean, whatever confidences they were supposed to hold. Well, I mean, all that got divulged.
I mean, in
And so, I
healthcare,
don't know.
correct me if I'm wrong, Omar, but you could just ignore a subpoena, right? You would need like the HIPAA release, correct?
Well, you would object, because it's privileged information, and they're
Unless you're Stephanie Jones, then you would not object. You would just give it to him.
Well, I mean, they eventually got signed documents for the release of medical records in the Owens v. Eckerd case after.
Yeah, you can't
trying
just
to dodge that, right?
You can't
Well,
ignore
those medical records were fake, Bruce.
Look,
I wouldn't ignore the subpoena. You just lodge the appropriate objections, and then the judge would deal with it.
so you can file a motion to quash the subpoena.
Yeah, based on privileges.
As long as you write it correctly, like our friend Chase J. Jones.
You could literally just check a box and just say privileged, and then you'd probably have a hearing on it, as I believe they did in Owens v. Eckerd. Didn't they have a hearing?
They had a hearing in February where both parties agreed to provide medical records to each other's counsel, and so they signed the HIPAA releases there because they wanted, to be able to, I think, initial a date change or a provider change, and then the judge was going to sign it as well, which would help with the release of the information.
I see. Yeah, I mean, the implications of, I don't know, they're far-reaching. I don't know to the extent that all of that stuff was breached, whoever's confidences were breached. I mean, the fallout from that, I don't know yet.
But yeah, the thing Lauren was showing us was so broad, I was kind of blown away because
very.
In the Owens v. Eckerd case, they said, look, it's only going to go from this date to this date. It's only going to cover these medical aspects. It's not going to cover these other aspects if they even exist, right?
Well, just imagine, Bruce. Let's just say that somebody subpoenaed your cell phone. They want your entire phone.
Don't you dare!
But it's only related to your communications with me. That would be
Don't you dare! Again, that's even
megabyte
worse.
of information on your phone, based on like the 1 terabyte of stuff that you might have on there.
Yeah.
And so,
it'd be like pages and pages of terroristic threats to Omar. That would be terrible.
I mean, the issue with the subpoena is not that it was issued; it was just that it was issued with nobody to notify. They were required to notify nobody. Even if Stephanie Jones had counsel, I mean, her counsel wasn't given notice, and she didn't know enough maybe to alert her counsel. I don't know what she did. I don't even know if she had an attorney at that point.
She confirmed with her psychic, obviously.
Yeah, but the fact that it was so broad and like obviously objectionable, and they got so much information from it is what makes it shady.
Oh, yeah.
And like I said, I mean, I don't know.
They drag her into a conference room with buff security guards hanging around or whatever.
I mean, I don't know. I don't know that it amounts to like criminal charges. I don't know if it goes that far. it just amounts to an extreme abusive process that I don't think that this judge, just gauging what a stickler he's been so far, is going to take time to.
It seems like a good way to get a lot of evidence excluded from a trial.
That's what I'm thinking. And my guess is that Friedman is going to try his damnedest to gut their lawsuit, make inadmissible all of their evidence. And that would mean that basically they really can't talk about much.
Question about the judge. So people have been, I've seen lots of comments that are saying the judge is biased or he's been ruling in Blake's favor.
No, he's not,
I don't think so either, but I'm like, how do you ease the minds of people who don't really understand that and who are thinking like the judge is biased or the judge is going to do this or that? Because even if the judge rules against, Justin's favor, that doesn't mean he's biased. He's just like, I feel like he's doing a thorough, good job.
Well, I think to ease the mind, like, for example, in the Owens v. Eckert case, they gave the petitioner the one break in the hearing. Okay. And even in like this Lori Daybell trial, you could see the judge was like trying to help her. It wasn't because there was a bias. He was making good rulings on the objections in general, right? It's more, I think you want to minimize the appealability, right? The exposure to an appeal for your case. You definitely don't want an appeal to go through. So you kind of have to, do your best there.
Yeah. Well, I feel like the judge has been I feel like he's been pretty impartial, especially listening to that hearing, what was it, like a month ago or so now? Maybe a little more than that. So, yeah.
The attorney guy's only provisions.
Yeah, he was really, he was kind of grilling everyone equally, I felt like. So.
Look, attorneys could deal with judges being sticklers for the rules. And the one thing he didn't do for Baldoni is grant them an extension. He just said, look, you haven't given me good cause why I should grant this. So your deadline's on the 18th. That's all he said. But he was like that for both sides. I mean, there's no evidence that was favoring one side or the other. It's like, look, I could appreciate a judge where I know that if they're going to be a stickler, fine, then we can operate that way. But where the decisions don't make sense is where, you'll find some bias. But in this case, there's no evidence of that. I think that he's been pretty even-handed. Matter of fact, both sides have come away arguing when the judges made decisions in this case that they were victorious for different reasons. That's a sign of a good, even-handed judge.
I'm going to ask and explain like I'm 5 question here. So for people who don't understand, and that includes me, to be honest, don't understand why. So that deadline to amend the complaint, why is it that deadline passed, right? So they can't do that anymore. But if he grants in part a motion to dismiss, they can amend the complaint. Why is that?
Well, my thought was, because I know where you're going with that, but so the deadline was April 18th for them to voluntarily amend the complaints.
Yeah.
Their arguments was, look, we're going to have some direction from the court. We expect these 12B6 motions to be ruled on. At that point, the judge could direct us whether or not he wants us to amend these complaints. And then the judge had made mention, you guys have been talking about amending the complaint in your responses, so I don't feel a need, if you feel you need to do that, to move the deadline. You guys have already been making intimations that that's what you want to do. Mm-hmm. But there's nothing that states that once that deadline passes, the judge is not going to re-grant them the ability to amend after he makes the decision. It's just the deadline was for them to voluntarily do it without any feedback from the court, which would be a waste of time. Why would you do that? Because let's say they amend it, and then there's still these issues in the 12B6. The judge might have further stuff. And so it's, screw it, we're just not going to do it. They probably double-checked and triple-checked the rules. If we let this deadline pass, when the judge makes his 12B6 rulings, is it going to foreclose on our ability to amend? The answer to that is no. So they're saying, why would we voluntarily amend? Let's just wait for the decisions then.
That's another thing that also happened in the Owens v. Eckert case. In the February hearing, the judge said, hey, I'm denying this motion to dismiss. And because we're going to do more evidentiary work and an evidentiary hearing beyond this, you can amend your original petition.
What complaint was that? Were you talking about Owens v. Eckert?
Owens v. Eckert, yeah.
My mind is so not right there right now. I'm trying to shift my brain over to that case.
It's basically what you just described, though, in terms of procedure. The procedures are, parallel. They're equivalent.
Right. And so that's why I think they did that. Is all.
So these things, if they go into second amended complaint, we then go through the process again where they will probably file a motion to dismiss and all that. Is that right? Like, you think that will happen, or?
I mean, you could refile a 12b6 based on a second amended complaint, and then it's going to be okay. What the fuck? Because at that point, we was like, you tell me what was wrong with the complaint and what needed to be fixed. The judge directed us what needed to be fixed, and we fixed those things. If it's wrong after that, if it's not legitimately wrong, the judge is going to be pissed.
Okay.
Like, what are we doing?
I was going to say, how often does that happen? But I guess not.
I've seen it happen. I've seen it. I haven't seen it happen with attorneys, but I've seen it happen with pro pers, where their complaints are constantly demurrable, and then it's like, Your Honor, I don't want to file another demur, but this is like their fourth amended complaint, and it's still wrong. I would be committing malpractice if I didn't point this out. Mm-hmm. And then the judge would be like, could you just please like get a free consultation somewhere or something or do something? But they're reluctant to just like dismiss the case because they want the case heard on its merits, and they're trying to be sympathetic to this person that's not being represented by an attorney, but you can only go so far with that. And so it just depends. It's a case by case. I've seen it go as far as 3 amended complaints. I haven't seen it go further than that. Maybe I have. I just don't remember.
So no FACs, which is disappointing for me because I kind of want to see an FAC.
No, there's going to be a SAC, a bunch of sacks.
I know. I was so disappointed when I thought I wasn't going to get to see any sacks.
Oh, boy.
Tell me that didn't cross your mind, all right? Well,
I mean, not until you said it.
Well, don't lie to me, dude. I know you've been... Bruce is more mature than we are, so he probably hasn't.
I don't know. It depends on what day you catch Bruce. Sometimes he's the more mature one. Others.
I mean, what you're saying makes sense, right? Like in Owens v. Eckerd, we didn't see a bunch of goofy multiple motions to dismiss or anything like that.
Right. At some point, you just want to get the litigation over with.
Because there were actual lawyers, even our friend, Mr. Gingras.
Like if I know that I'm trying to get past the amended complaints, because I want to file like a motion for summary judgment, I just won't object, and I'll just file the motion for summary judgment because that's going to lead to a dismissal. It just depends. Everything's case by case.
Yeah, makes sense.
All right. Well, I don't know if there's anything else we need to cover tonight. Hang on, let me see these star chats because I got to get to bed soon. Jess Ricardo, thank you for the 2. Subpoena Winfrey. You get one and you get one. I'm not subpoenaing Oprah. You're welcome to do that, though. I'll watch. Jess Ricardo, thank you for the 2 again. Lyman ruled specifically against those times. Which times? I'm sorry. This was 10 minutes ago almost. I don't know exactly which times he's referring to. Ricardo, if you want to remind me in the chat right now, I'll take a look. Somebody's asking here, Craig in Omar's chat says, will the fair work rule for the New York Times be the fair reporting privilege, I think, for the New York Times be valid if they're reported from information from a discontinued lawsuit?
Yeah, that kind of gets back to your question we skipped, Lauren, I think.
Okay, yeah. Gotcha.
Oh, was it about the New York Times thing? The fair work rule?
Yeah.
Because if you remember their responses, or they had a motion to dismiss and there was a response in their response, I don't think they ever mentioned this other case, did they? That we're talking about now?
No. Well, if they did, then it wouldn't be such a big deal.
No one knew about this until recently. I saw this lawsuit because I looked up all their company lawsuits and stuff a while ago, and I was just like, no, that's stupid, and I just glossed over it. I just didn't think anything of it. I was like, this isn't anything, and so I just moved on to what I was doing. So nobody
isn't it
knew
true
about
that the Times all they did? But isn't it true all they did was report on the CRD complaint?
Yes, correct.
Then why would they be in trouble for that?
Because the subpoenaed information, I guess, was actually not from the CRD complaint, and the thousands of pages of text messages they went through was not from that at all. I think that's what they're getting at.
In my opinion, if all they did was report on what they were given and they had no reason to think that it was like nefariously obtained, how would they even know that?
What if they were like doing that before the CRD complaint was even in motion, like even before they even started drafting that? Does that
how would you prove it?
The metadata in their article said that they started it in October, in the early October, I think it was.
So if they had access that this was like a sham lawsuit and they didn't report on it,
right? Well, they started it right after they got the subpoena for this sham lawsuit. So the sham lawsuit information was what they used to start drafting their article, allegedly.
It's like their drafts are a little too early.
Right.
I mean, there's nothing
Is
wrong with it.
that a problem or not?
Right.
Personally, I don't think it is, unless they're printing something knowingly false, which I haven't seen any evidence that they have.
Right.
If all they're reporting on is what has been filed, then I think that the fair reporting privilege sticks.
Mhm.
Honestly,
What if they had things? What if they had the CRD draft plus a pile of other stuff?
Why don't you just give them the whole cell phone if they don't report on all those things? What does it matter if they're not disclosing like their confidential sources?
It sounds like they actually did give them the whole cell phone.
No.
Yeah,
So
I
they
mean,
might.
That's when I said there's a whole extra pile of stuff. That's what I'm talking about.
Right.
Let me give you an example. What if I gave you the entire Watergate files?
Fuck that. I'm busy.
How would you even know what you're looking at
I wouldn't.
if you're just a reporter? You know.
Well, I would ask you, where did this come from? Is it legitimate? Am I allowed to have this? Why the
They
fuck are
don't
you
have to
giving it
reveal
to
their
me?
sources. And so look, they don't have to. Nobody reported that Richard Nixon has like a spawned, this whatever. It wasn't that the reporting wasn't that. It was just like, hey, this like all these things have happened, and it was kind of like going out there. They didn't make wild assumptions. That's what reporting is. Like you report like what you know is true. You could write opinion pieces. That's allowed, but you gotta categorize them as an opinion piece. You report the facts that are the facts. And so I haven't seen anything that the New York Times has done where they reported anything that wasn't factually true.
I mean,
they may very well have known things that were nefarious on the lively part, but
right, yeah.
So what?
At least factually an allegation.
I mean, at the end of the day, I think this is going to have to come down to social consequences. I don't think the court's really going to do anything about. And I know that's not a popular opinion. I think they're going to get away with it in court, obviously, because they can skirt around and like technically they haven't done anything wrong based on the law. But like obviously, when you look at their reporting practices and you look at what happened here, if things turn out in Justin Baldoni's favor, people are going to have to take a look at the New York Times and say, "Hey, why the fuck did you lead me to believe?" XYZ happened when obviously that wasn't the case. And then that maybe then we'll start to have some backlash in a public opinion perspective, not so much in a legal perspective at all.
That's the thing. I mean, people comment. I mean, honestly, the entire news industry has been built on prognosticators, people making predictions, people opining on what's going to happen. These political people they're taking these stances or whatever, they could say basically whatever they want. And as long as they don't say anything that's factually untrue, they're pretty much protected. That's kind of what the New York Times, you can be as pissed at them as you want. I just don't see where they have done anything wrong. If all they did was report on what Lively filed in December of 24.
Are you saying their story was a commentary piece, not a news piece?
I'm saying nothing.
Megan Toohey made a lot of comments, and I didn't like it. So,
I mean, look, there's a lot of reasons.
I think I got your bishop in the corner, Omar.
What happened?
I think I have your bishop in the corner now.
Oh no, because I gave my king
not the fucking
I gave my king a square.
Oh boy.
Oh my lord.
And I'll take the free bishop. Thank you, sir.
Dude, oh god. Okay, I gotta go to bed because I gotta swim in what 5 hours and so like 5.5 hours. Yeah, I gotta go in 5.5 hours. So I gotta go to sleep. Omar, Bruce, or you have anything else you want to say before we close it out here?
Only that I love you all, and I hope you guys have the sweetest of dreams. And be safe, and don't do anything that I wouldn't do.
That is not very limiting, but thank you, I guess. Bruce, anything else you wanted to talk about?
Pineapple, taxi cab, monkey underpants.
All right, we can talk about that privately. You don't have to air you do not have to air our business out to everybody. All right, thanks everybody. I'm going to close out the live stream now, but we'll see you all soon. Bye.
All right, folks. Bye-bye.